Good morning, Liberty. It is Wednesday morning, June 14th, 2019. My name is Michael Boldin, broadcasting to you live from my home office and studio here in downtown Los Angeles for the 10th Amendment Center, as we do just about every single Monday, Wednesday, Friday at 9:30 a.m. Pacific time. Now, today on this episode, I'm going to talk with you. First of all, thank you for joining me. I really appreciate it. On this episode, we're going to talk about the Supreme Court. The last few days, and I think this is the season, I've heard a lot of people talking about the Supreme Court, whether it's through podcasts or videos on YouTube or news reports. We put news in quotes sometimes, blogs, social media posts, and the like. And a lot of people are talking about, because the Supreme Court ends its term generally by the last week of June and preps for the next term in October around this time, or shapes the next term, that is. And everyone's talking about what position they're going to take on a various case, or which ones they've rejected, they've decided not to even hear, etc. And I'm not going to talk about free speech cases or silencers or Marbury versus Madison. I might mention Wickard, but who knows? I don't really want to talk necessarily about the specifics, the nitty-gritty of the cases, because I think that's a distraction of the bigger picture, the more important thing that most people tend to miss or just ignore, because it's easy to get caught up in the garbage that Washington, D.C., that government throws at us from all directions. And two things that I think are really, really missed in most commentary is, one, does the Supreme Court ever really do a good job of limiting the power of the federal government? And I can tell you right off the bat, I think no, but I want to provide you guys with some actual concrete evidence to back up that view, that it's not really a good approach. If you believe in liberty, now I talk about this all the time, if you believe in liberty, you want to restrict the power of the federal government under the Constitution. James Madison, for example, in Federalist 46, he did not recommend as one of his 4 steps to do so as going to the federal courts to stop federal power. In times when the federal courts, which are part of the federal government, are part of the problem, you can't rely on them. And that's what we are told, both by Madison, Jefferson, many others. Now, the other part, I think, is what should be the role of the federal courts today? Or should it be the same role that we have today? I think that's better explained. And the way most people look at the Constitution today is this. They tell us that the Constitution means what the Supreme Court tells us it means until it changes its mind. Now, I can't find anywhere in any of the ratification debates, any of the notes on the convention in Philadelphia, any statement by any of the founders saying that the Supreme Court is the one who tells us in all cases, all the time, what the meaning of the Constitution is. And it's actually the other way around. The Constitution means what the Constitution means, and what it means is what was ratified by the people of the several states. It means what it means, even when the Supreme Court has an opinion saying something completely different. So let's get into that in just a little bit. I do want to say hi to some people out on the live chat. I appreciate everyone joining me here today. Shane Lackey, Joseph Standridge, good to see you here back on the live stream. Been a while. Ward Lawrence. Justin Bayola over on YouTube. Do You Love Me Forever? That is an awesome screen name. Courtney, Heather Rossi, EHP Training. Good to see you, buddy. Domo, haven't seen you in a while. Heather Lee, also over on YouTube. Christ Saves, Rocky Branch, Suzanne Sherman, Dennis Marburger. I love you guys. Glad to see you here. Over on Facebook, Michael Bogus, Pamela Rankin, Dawn Frya, and I apologize if I'm missing everybody. I really appreciate everyone who joins me here. We broadcast live again Monday, Wednesday, Friday, 9:30 a.m. Pacific time through our channels over at YouTube, Facebook, DLive, Twitch.tv, and Periscope. Plus, we have our archives and a podcast version. So we also put the video up on BitChute and sometimes BitTube, but it's not that reliable. I'm assuming we'll use Voice once that comes out, the blockchain-based project from Block One EOS. Plus, we also have the podcast version, iTunes, Spotify, and elsewhere. I appreciate all the reviews. Thank you, everyone who's been leaving reviews over on iTunes. They are really awesome. One of these days, I'm just going to go through them, maybe live, and thank some people. But find all of our archives over at 10thamendmentcenter.com/Good Morning Liberty. So let's get into this a little bit here today. I want to first cover this article from the Volokh conspiracy. I apologize if I pronounced that wrong. But again, links are in the show notes. If you're on YouTube, you can kind of play along. I generally put them in order before the show, but not always the best job. But of course, 10thamendmentcenter.com/Good Morning Liberty, to plug that again, is where you can find it if you're wanting to pay attention in the archives. We publish those generally about 30 minutes or so after the live broadcast is over. So Volokh conspiracy over at Reason Magazine from Keith Whittington. This came out just, I guess, about a week or so ago. How often has the U.S. Supreme Court upheld a federal law? We have lists of, and I'm going to get into this, we have records of how many times it has struck down part or all of a federal law. But no one's really done much of a study on how many times it has upheld it. And one thing that Keith says here is first of all, I want to add one thing that just kind of sticks in my head. When the Supreme Court issues a, quote, ruling, it isn't a ruling because the Supreme Court doesn't make law. The Supreme Court issues its opinion on the constitutionality of a particular law or act or regulation, whatever it may be. And even in the Supreme Court documents itself, it calls its own opinion an opinion. So we have to recognize that everyone has an opinion on the constitutionality of something. It doesn't mean that someone is right or someone is wrong. The only thing that's right is the Constitution. Now, when I talk about the constitutionality of something, I'd like to think I'm right every single time. I'm probably not. Actually, I guarantee you that I am not always correct, but I do my best. Mind you, I have opinions on this. I am not making law. I'm just trying to tell you from what I've seen from the founders themselves, what they intended, and then what the people approved in the ratification debates. So Keith writes here, the simple fact is that throughout its history, the court has mostly used the power of judicial review to validate congressional actions and to explain why there are no constitutional problems with the ways in which the legislature is exerting power. When a constitutional challenge has reached the court, the justices have been far more likely to uphold a federal law than strike it down. And he's actually doing this based on research on how many times this has happened. The court is far more likely, he writes, to approve of congressional exertions than tell Congress it has gone too far. The court has mostly acted as a handmaiden to congressional power. I think the proper term is rubber stamp. Now, Congress started actually compiling the amount of times that the Supreme Court struck down an act. And I think Keith gets into this as well, because Congress doesn't like when their power is restricted. Neither does the executive branch. Neither does the judiciary. None of these people in power like power. They go for the power. They're not going there necessarily to get rich. Power is its own richness in many ways to certain people. Not to me. I think most good people don't even want to be in positions of power because it's gross. Anyway, so he says politically this is to be expected. The courts are able to, well, actually, I'm jumping forward here. There's an interesting quote that he has from the Anti-Federalist, which is a term of art. It's a propaganda term. Brutus, and I don't think he's using it that way. It's just what they're called. Brutus would not have been surprised. He warned us that the court would, on the whole, enhance rather than limit congressional power. He says, quote, the judicial power of the United States. Now, this was during the ratification debates, the consideration of the Constitution as it was proposed. The judicial power of the United States, he wrote, will lean strongly in favor of the general government. Wow, what an amazing prediction. And Congress would soon take its guidance on the proper scope of its power, not from the Constitution itself, but from what the court has said about the Constitution and what the judges are willing to uphold and apply. Now, that is an incredible prediction, some incredible foresight and analysis of what was going on in the consideration of the Constitution. Look, under this proposal here, you got to be careful, because if people are going to say that the Supreme Court has final authority, and if that's the case, no one's going to care what's in the words of the document. They're only going to care what the court says. And people like the great Kevin Gutzman, who I got really that idea of this, the people think that the Constitution means what the Supreme Court says it means. That's where I got that kind of concept, was from Kevin many years ago. But he talks about, as someone with a law degree, he talks about what it's like to go through law school. And I think he's been very clear talking about the fact that people training to be lawyers do not study the origination of the Constitution. They don't study what the founders intended. They don't study what the debates for and against, the concerns. They don't study the ratification debates. This is totally ignored because it has no impact on the practical meaning for a lawyer of what the Constitution is as applied today, as twisted today. He says, I think they start with Marbury versus Madison, and then only look at Supreme Court precedent. And this is basically what Brutus warned about. If you create this system, or you have a system where the Supreme Court is the ultimate arbiter, then it doesn't matter what the words say. All that matters are the Supreme Court opinions. And Keith goes on and he writes, politically, this is to be expected. The courts are able to sustain a power of judicial review because tolerating such a power is not too burdensome to other government officials. So long as the courts are mostly upholding what Congress does, Congress can abide the relatively rare occasions when the courts make a bit of trouble by striking something down. So let's take a look. When do they strike things down? If you're watching on the video, you can see this kind of graph, I guess you'd call it, this graph of how many times they've upheld a federal act or how many times they strike one down. Now, mind you, it's not high numbers, but let's look here in, what is this, around 1975 or so? They upheld 13 cases, and it looks like somewhere between 2 and 3 they struck down. So that's a pretty significant difference. At its peak here, they upheld in 1937 probably. They upheld 15, and maybe they struck down about 3. In recent years, it has actually kind of ebbed and flowed, gotten a little bit more equal, but the balance has long been the other direction. So I started thinking, as I was looking at this a little bit deeper, I got to thinking, like, how many times have they struck things down? I know that Mike Meharry and I have covered this in the past in some reporting and in our conversations, but I want to look into it a little bit deeper. So I found this article that I think Tom Woods has cited on a recent podcast. I can't remember the episode, maybe like 1401 or something like that. But it's this research paper from 2011, the U.S. Constitution's Commerce Clause, the Supreme Court, and Public Health. And there's really just one quote that I think really strikes out. Between 1937 and 1995, nearly 60 years, the Supreme Court developed an extremely expansive view of the Commerce Clause. Now, we're just talking about Commerce Clause jurisprudence. Not general welfare, not necessary and proper, not any of these other ones. Just Commerce Clause. In fact, no federal laws were found to violate Congress's commerce power during this period. So in 60 years, they passed whatever they wanted, as long as they were claiming it was interstate commerce. The Supreme Court would agree. The most far-reaching decision came in Wickard versus Filburn. That's this case where the federal government told someone that if they grew wheat in their own backyard for their own consumption and own use, this was somehow affecting the interstate commerce of wheat. And because they were doing price controls and all kinds of other crazy statist garbage at the time, which is, I mean, it's probably far worse today, but that this person wasn't allowed to grow a certain amount. He had to destroy it. And the court held in the favor of the government. Now, this report actually talks about there was a reversal from this consistent 60 years of saying everything is commerce. And that was in a case U.S. versus Lopez. But we know that just a few years later, in 2005, the case of Gonzalez versus Rage. This is the famous marijuana case where Scalia took this same huge, expansive Commerce Clause power view of the federal government, saying that if you grew 6 plants in your backyard never bought or sold them, never took them across state lines, consumed them in your own home, this was somehow something that affected interstate commerce, and the federal government could do whatever it wanted. It could regulate, ban, prohibit, control, stomp them out, take the property, probably lock you up, whatever. The only person that really had a thoughtful rejection of that view was Clarence Thomas. And I think he issued basically a warning. I think he was basically saying, like, look, if you do this, they're going to claim the power to regulate everything from a bake sale to a rummage sale, maybe everything in between. And I'm paraphrasing. And for those of you who follow the whole lemonade stand issue, that warning, I think, is playing out pretty clearly. So under the commerce power, for 60 years, not one thing was struck down by the Supreme Court. The Supreme Court did not take an opinion that anything violated the Constitution. And then if you couple that with the view that the people incorrectly have, that the commerce power means what the Supreme Court tells us it means, rather than having the position of, we know what the commerce power means, and the Supreme Court is wrong, so they may have their opinion, but we're going to do what we want anyways. And I think that kind of came out if you watched my episode about Angel Rach and the cannabis strategy. You could see that Angel was saying in that case that if she lost, she was going to move to Canada. But at some point, she had a change of heart and recognized that once the Supreme Court handed down its opinion, she said, look, I'm going to continue doing what I do to treat cancer and help other people, even though the Supreme Court says otherwise. And that's the mentality people should have as a knee-jerk reaction, in my view. Now, take a look at this link. This was most recently updated in 2011, and there's not much change from the first time that I looked at it, a 2006 view. Acts of Congress held unconstitutional in whole or in part by the Supreme Court of the United States. It's literally the entire list. It's a compilation of every single time the Supreme Court has taken a position that part or all of a federal act is unconstitutional. Now, I think it should be separated between part and whole, because a lot of times when they supposedly strike down part of something, they're leaving a lot of other unconstitutional garbage. So I think even this is inflated. And the 2006 update that I usually have referenced in my own research had 158 in history. This is from day one after the Constitution went into effect. Day one. 158 as of 2006, and then as of 2014, I'm scrolling through here. Sorry, I think it's more. It's definitely more. It is now up to 182. As of 2014, the most recent one held unconstitutional was an act of December 2006. So it looks like, at least from what I'm reading here, that they didn't strike anything down for like 8 years. I don't know if that's correct or not, or if I'm actually reading that properly. But yeah, so 182 times in history. Now, maybe that's a lot. Now, if Congress was following the Constitution most of the time, and they weren't passing much, you could say, well, 182 times, man, that is pretty good. Like, that's like half. If Congress was only passing 1 or 2 laws a year, this would be amazing. So I'm thinking, I know they say that there's 20, 30, 40,000 pages of regulations on the books in the Federal Register. How many laws have they passed? It's interesting that Wikipedia has a nice compiled list. And in recent years, I see many of modern Congresses pass 400, 500, 600 laws per session. So far this session, the 2019, I think they've passed 15 or 20. But according to Wiki here, it says, and I should pull this up for people watching, quote, Congress has enacted approximately 200 to 600 statutes during each of its 115 biennial terms, so that more than 20,000 statutes have been enacted since 1789. 20,000. So 182. Now, my math sucks. I went to a government school, so I didn't learn a lot there. I had to learn things on my own. Let me just do a little math here. 182 divided by 20,000 is 0.0091. So about 1%. 1%. If you think the federal government does have the power to tell you what kind of plant you can grow and consume in your backyard, if they have the power to tell you what kind of light bulb that you can own, how much water your toilet can have, if they have the power to tell you that shall not be infringed means something other than shall not be infringed, like shall not be infringed as long as you don't put an attachment on it, shall not be infringed as long as it doesn't fire too fast, shall not be infringed unless the caliber is too big. If you have that view, then striking down or holding or taking the opinion that 1% of congressional acts are unconstitutional is totally in line with what things should be. Now, if you have that view, you probably don't listen to what I have to say. You think I'm a complete idiot. But on the other hand, if, like I do, you believe that it's very easy to say that 90+% of what Congress, the federal government, has done in modern times has nothing to do with the Founders' Constitution that came out of Philadelphia, that was ratified by the people of the several states, this is totally backwards. This is a rubber stamp. Now, they don't consider all of these acts, but basically the way things have played out is that what Congress does is assumed to be constitutional because people have the wrong mentality of how the Constitution is supposed to be read. They can't consider that many pieces of legislation. Maybe if the Supreme Court was actually considering everything, maybe they would hold many more to be unconstitutional. I don't know. The percentage, at least in the numbers of what they've upheld in the ones they've considered versus not, I think it's like 80%. I don't know. I don't trust them. Their track record has not been very good. So 1% of all the ones that have been passed is totally backwards. It's not actually working right. So the problem, I think, is twofold. The court is actually acting like a rubber stamp, and two, the people, even if they view it that way, like they're acting like a rubber stamp, they treat that with validity. They don't take action. They don't do what they're supposed to do in response to unconstitutional acts. If they have an opinion, oh, that's unconstitutional, they wait for the Supreme Court to tell them. It's like saying, I have the right to keep and bear arms, but I'm not going to exercise that right until the Supreme Court strikes down such and such a restriction on that. So that doesn't really work. But the weed people, on the other hand, even in the face of Gonzalez versus Raich, where they basically said that the federal government was supreme on marijuana prohibition, the people did it anyways, and many people went to jail for a decade or longer in the early days. Now, clearly, if you've only been paying attention for the last couple of years, you're going to think, well, there's very little risk to that. The reason there is very little risk to that is because so many people took that risk early on, went to prison, lost their property. Somebody even died in jail here in Southern California going through this. People lost their property, their liberty, and in some rare cases, their life in this type of a situation. And today, there is very little risk because so many people were willing to exercise their rights, what they believed in, even though the Supreme Court said they couldn't. So it's a twofold problem. And I want to get into that a little further. Now, Thomas Jefferson, he specifically talked about this. He was very concerned about the people taking a view that the Supreme Court, that these unelected, unaccountable, politically connected lawyers that make up the Supreme Court, Thomas D. Lorenzo refused to them. He calls them black robe deities, basically, and I think that's a good way to put it. But he was warning people for many, many years against this type of approach to the constitutionality of federal acts. Here's a letter from Jefferson to his friend William Charles Jarvis on September 28, 1820. He says, quote, "You seem, in pages 84 and 148, to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." Now, that's Jefferson's words. I happen to agree with it. Some people on the left will say, oh, it's a fascist system running the country today. And other people will say, well, they're socialists, they're statists. I think a great way to describe what the country is now is an oligarchy. And that's how Jefferson described it. Basically, we have these unelected, unaccountable handful of people who are basically telling us what our Constitution is supposed to mean. It should be the other way around. the people should say, well, this is what it's going to mean no matter what. Now, that's not necessarily saying that the people are really educated on liberty or the Constitution at this point, so it's all kind of a dangerous game. But Jefferson said this is a dangerous doctrine to turn to this handful of people to determine the constitutionality of everything. He also said this. Oh, where's the quote? We posted it on our social channels a little earlier this morning. There is no, and this is a truncated quote that I'll get in full in a moment. There is no danger I apprehend so much as the consolidation of our government by the Supreme Court. And the full quote goes like this, and this was a letter to William Johnson in March of 1823. In truth, he says, there is no danger I apprehend so much as the consolidation of our government by the noiseless and therefore unalarming instrumentality of the Supreme Court. He says, I cannot lay down my pen without recurring to one of the subjects of my former letter. So he says you are going to get a slow expansion of power. Both he and James Madison warned us that if you turn to the federal government, you rely on the federal government to determine the extent of its own powers, you should never be surprised if that power grows and grows and grows. And I got news for you guys. I know you know this. The Supreme Court is part of the federal government. So basically, if your strategy for liberty is to go to the federal government in the hopes that the federal government is going to limit the powers of the federal government, you've already lost. Now, that's not to say that a lawsuit strategy is always a bad one. For here at the 10th Amendment Center, for me, it really is. There may be a case in some point in the future that it's different. I know my buddy Mike Meharry is involved in a lawsuit in Lexington, Kentucky, because he wants to point out how they're doing unconstitutional surveillance. Well, they're suing him because he basically did it's like a freedom of information request. It's called an open records request, and they're suing him, and he's basically defending himself, saying, look, you gave this to me, now you're going to charge me for this? I don't know if they're trying to bill him or give him a criminal charge. They basically told him in court the other day, there were some oral arguments, they basically suggested that the only person who would want these type of records is a criminal. So I don't know if they want to go after him. They're definitely suing to prevent him from having access to information. It's shining light on what government is doing. So this article from Seth Del Conte, I wish Seth was still blogging for us. He writes some really good stuff. I haven't heard from him for quite a while. But he goes a little bit deeper into Jefferson and Madison versus Supreme Court supremacy. This idea that the Supreme Court tells us what the Constitution means rather than helps us understand through their opinion on it. And he's got a lot. This was basically covering the Affordable Care Act. Again, the link is in the show notes, but he has this section called Judicial Branch Supremacy. And he says, in the Kentucky resolutions, Jefferson went even further to explain that since there was no common judge in the compact between the parties, the states, that agreed to it, then, quote, each party, that is, each state, has an equal right to judge for itself in questions of federal power. And this would ostensibly include unconstitutional judicial rulings or opinions, I think is the better term. So he's saying each state has the right to determine the constitutionality of an act. And when Jefferson and Madison covered this more in his report of 1800, covering the resolutions of 1798, when they talk about the states in this kind of scenario, they're talking about the people of the several states. So each independent sovereign, the people of each state. Now, they may think of things differently. We're not necessarily talking about the government of each state. And Seth goes on. He says, Madison agreed with Jefferson. Oh, and I didn't pull this up. Sorry about that. Second Amendment for Canada is right, says begging slave masters for freedom. And I'm going to get, there's tons of great comments here that I'm seeing kind of scroll by, so I really appreciate that. Lots on YouTube. So let me pull this up. I don't know why it's not switching over. There we go. There's the video. Madison agreed with Jefferson that the states maintained an ultimate right to judge if the Constitution has been violated by any of the three branches of the federal government, the judiciary included. So Madison is saying that the ultimate right, Madison's terms, or Jefferson's, is up to the people of the states, not the Supreme Court, not the federal government. And this is Madison's terms. He says the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. Nice reminder, James Madison. We recognize that all branches of government could do something wrong. Just because they have a black dress on does not mean that federal judges are infallible. We should stop treating them that way, whether individually, and I know most people treat basically individual judges as fallible creatures. And they hate the conservative ones from the left, and they hate the liberal ones from the right, but they still treat collectively, with a collectivist mindset, the edicts of the Supreme Court as final and binding, when they should be treated as an opinion, because that's what they are. That's what even the Supreme Court tells us they are. So a great reminder from Madison: the judicial department may exercise or sanction dangerous powers beyond the grant of the Constitution. And consequently, Madison writes, the ultimate rights of the parties to the Constitution to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or the legislature. And he's saying this is up to the people of the several states. Each state can make their own determination of whether the agreement, the compact that it participates in, has been violated by the creature that was made by the agreement of the several states. Seth goes on. He says, Madison maintained that the judiciary is the final arbiter in disputes between federal branches. Now, he had a different view than Jefferson, and I think it creates an interesting debate. Madison, I think, was far more middle of the road. He really wanted more centralization of power than what he got, but I think he was very honest. Personally, I think he was honest in what he was talking about, and he maintained that the judiciary is the final say when there's a dispute between Congress and the executive branch, or with the judiciary. Basically, if there's a conflict between any of those three branches of the federal government, it was up to the Supreme Court. But quote, can never have the final say in cases involving a dispute with the states over constitutionality, since all the branches of government derive their delegated parties from the parties to the compact, that is the states. So how can, if the people of the states, or if just the states, so I don't have to keep repeating that, if the states created the federal government, how can the federal government tell the states what they created? And I think that's the really important point. And he says this is in Madison's words, and I think it's worth to read through this a little bit more in detail. I know I'm running a little bit longer than I'd like to go, but it's really important stuff. However true, Madison writes, therefore it may be that the judicial department is in all questions submitted to it by the form of the Constitution to decide in the last resort. This resort must necessarily be deemed the last in relation to the authorities of the other departments of the government, not in relation to the rights of the parties to the constitutional compact, from which the judicial, as well as the other departments, hold their delegated trusts. Again, just like Seth said, Madison tells us that the Supreme Court has the final say in disputes between branches of the federal government. But when it comes to the federal government versus the states, it can have an opinion, but if the states take a different view, the feds lose. Now, Jefferson agreed, but he took a far more expansive view. It wasn't just, check this out. He wrote a letter to Spencer Roane in 1819, and Seth writes this. Jefferson plainly declared his view that the judicial branch of the federal government is not the final interpreter of the Constitution, be it for disputes between the government and the states, or even disputes between governmental branches. Basically, it's a part of the process, it has its opinion, and if people agree with it in practice, then that holds. He went on to warn, Seth writes, that if this doctrine of unconditional, absolute judicial interpretation were correct, then the judicial branch's manipulation of the Constitution would be limitless, and there would be nothing left to keep it in check. You have to understand that if you want to keep the federal government in check, you need something outside the federal government to do it. You cannot rely on, I was a pretty bad kid. Like, I was always getting in trouble. If it was up to me what my punishment was going to be, if my mother was dumb enough to say, you know what, you choose what you're allowed to do, I would have done whatever. I had no check If I had absolutely no check, I would never get punished. I would never get in trouble. I mean, not necessarily that putting a lot of strict lines around my activities really did an amazing job. But if I could have just had a free-for-all, I think it would have been a whole different story. Parents don't work like that. Why do the parents of the constitutional system treat the child, the federal government, as having ultimate authority over itself? Jefferson put it this way. He asserted that the Constitution allows each department of government to ultimately determine its own interpretation of the Constitution in a dispute. And in a letter to John Adams' wife, I can't think of her off the top of my head, maybe Suzanne Sherman, if she's still watching, she would definitely know. I can't think of her name, but he wrote talking about his opposition to the Alien and Sedition Acts. He said, as a president, once he was elected, it was his duty to actually thwart the implementation of the law at every turn. It wasn't just his duty just to enforce it because the Congress passed it. His duty is to the Constitution. Everyone who takes an oath to the Constitution, they take an oath to the Constitution as they understand it. They don't take an oath to the Constitution as long as the Supreme Court tells them that what they're doing is right or wrong. Basically, again, this is creating a king, an oligarchy amongst 9 unelected, unaccountable, politically connected lawyers. And in conclusion here, Seth writes, Madison pointed out a concept of uncontestable federal judicial supremacy over the states would be illogical. It would invalidate the state's authority to initially delegate such powers in the first place and could make the reversal of those usurped powers impossible. So looking over the live chat, Shane Lackey, who I really appreciate, the Supreme Court's opinion is ultimately non-binding. They don't have any way to enforce it. I mean, it really is just a position that people hold this view that the Supreme Court is supreme in everything. Sabolytic says, great reminder, Madison is one of my favorite founders. Yeah, absolutely. Let's take a look here. Andrew Nappy, good to see you, buddy. In the current Kaiser case, Breyer says, and I haven't looked at this, judges ruling on rulemaking agencies interpreting own rules is the biggest power grab since Marbury versus Madison. That's interesting. Maybe I'll actually have to look at some of these cases. I generally avoid them because I see this 0.009, this 1% of time of federal acts that are struck down. So once in a while, you're going to get something. But 99% of what they do is in effect. And that's why you have tens of thousands of laws on the books when there maybe should just be dozens or hundreds, something like that. So really interesting, interesting back and forth. Sabo also says Madison and Jefferson prove what can happen with debate of opposing views. Yeah, they had similar views, but one took it further than the other. And I think that is a legitimate debate. Absolutely. Abigail Adams, Dennis Marburger reminds me. Thank you. Dan Reed, good to see you as well, buddy. He says, an interesting point that is easily overlooked, but by we, not in law, but those opinions are given the weight of law. Yes. Yes, absolutely. People take what the Supreme Court issues as an opinion as law. And that's the Kevin Gutzman view, is that the people view it like this. And that's what creates the problem, because if no one takes action on their liberty, if no one exercises their rights unless they get a permission slip, whether it's a concealed carry license or an approval from the Supreme Court to be free, then you're not free. You are just a subject. And as Jefferson put it many times, that this is totally not what a free society does. And I think my favorite quote from him on that is specifically that a free people claim their rights as derived from the laws of nature and not as a gift from their chief magistrate. So I hope you guys found this interesting. Tom Rankin, I agree, absolutely, and good to see you as well. Supreme Court issues opinions, not law. The states are free to ignore them if they choose to. And of course, this is all strategic. Now, if you have kind of an outlier opinion on something and you see a Supreme Court opinion or a congressional act is unconstitutional and no one else agrees with you, the likelihood of you being able to pull this off in South Carolina or here in California or elsewhere is going to be far different. The key is to try to convince other states of this view. This is what Thomas Jefferson and James Madison did strategically in the Kentucky and Virginia resolutions of 1798, opposing the Alien and Sedition Acts. Those resolutions didn't nullify anything. It called for a nullification of it. It called on other states to join them. And then the strategy going forward from there was going to be further steps. Jefferson said we should, quote, push as far as events will render prudent. Now, they didn't end up having to do this because Jefferson was elected president, and this is one of the few times, it doesn't really happen in modern times, that electing a president means there's going to be less laws on the books, smaller government. He cut the size of the debt. He stopped enforcing the Alien and Sedition Act, things like that. That's a very rare situation. But yes, this was calling on other states to join, because if you try to go it alone, you're going to have a problem. Now, if California went it alone on cannabis back in 1996, which it did, it had a very difficult time. A lot of people went to prison back then. But as more and more states got on board, now it's 33 states, it's almost impossible. The feds don't have the manpower or the resources to get the job done. So hopefully this all makes a lot of sense. It's very interesting, educational, fun to watch. I really appreciate everyone who's joining me here today. Kent Myers, I agree. Problem is and always has been SCOTUS interpreting the Constitution. In a way I agree. I think the bigger problem is that people take their interpretation or their opinions on the Constitution, which I think everyone is entitled to, but taking their opinion as holding more weight and having the legal force of law in every situation, instead of saying, you know what, you have your opinion, now come and enforce it. I think that was the supposedly famous Andrew Jackson quote on the Federal Reserve or the central bank, something like that. I also said the same in a speech on the so-called constitutionality of Obamacare. I said the Supreme Court may have their opinion on Obamacare. This was back in 2010 in an event in Fort Worth, Texas. They actually used this in my Southern Poverty Law Center profile over at splc.org. That I just said, try and enforce it. It is really up to the people of the several states to exercise their rights, whether the government people want us to or not. Again, I'm very, very grateful to everyone joining me here today. Heather, Sabo, Kent, Second Amendment Canada, Courtney, Tom, Dennis, of course, and everybody else. I know I'm missing a bunch of people. I'm very grateful. Again, if you support the show, you want to smash the like, subscribe, leave some comments. Support us financially. It's 10thamendmentcenter.com/donate. I don't care if it's $1 or $1,000. We make the money go far. Everyone who works for the 10th Amendment Center, we do it in our own homes. And everyone who volunteers, which is the vast majority, we do it in our own home, on our own time. And it really, really is a grassroots effort. So every penny that you can throw our way is very much appreciated. Of course, we'll be back Friday and every Monday, Wednesday, Friday at 9:30 a.m. Pacific time. And the archives are over at 10thamendmentcenter.com/Good Morning Liberty. Again, I hope you found this interesting and fun to watch. I really, really appreciate you being here with me today. I hope you have a great Wednesday, and we'll see you on Friday.